Mr. Gore.
Mr. Chief Justice, may it please the Court. District 1 is not a racial gerrymander. Rather, the General Assembly largely preserved District 1 from the constitutional benchmark plan and made changes based on traditional criteria in politics. The panel acknowledged that the General Assembly pursued a political goal of increasing District 1's Republican vote share. It achieved that goal by moving Republicans into the district and Democrats out of the district. All of the direct evidence confirms that it used political data, not racial data, to identify Republicans and Democrats. The panel declared District 1 a racial gerrymander only by departing from this Court's precedents and adopting sua sponte, an erroneous racial target theory. First, the panel failed to enforce the alternative map requirement. In a circumstantial case like this, only such an alternative can disentangle race and politics. Second, the panel's racial target theory hyper-entangled race and politics and simply makes no sense. The panel believed the General Assembly needed a racial target in Charleston County to achieve its political goal district-wide. But a 17% racial target says nothing about voter turnout, says nothing whatsoever about the predominant majority of voters in predominantly white Charleston County, and also is irreconcilable with District 1's recent electoral history. Moreover, even the panel agreed that the General Assembly made political changes in other parts of District 1 without using a racial target. The General Assembly had no reason to and did not use a racial target. It used political data to pursue its political goals. If left uncorrected, the decision below will undermine this Court's holding that partisan gerrymandering claims are not justiciable. Partisan gerrymandering claims can always be repackaged as racial gerrymandering claims if all plaintiffs in lower courts have to do is ignore direct evidence of intent, infer a racial target from the correlation between race and politics, and point to malleable expert analysis. This Court should reverse and not allow its exacting precedents to be so easily subverted. I welcome the Court's questions.
Mr. Gore, we review this for clear error, and the district court credited the plaintiff's expert and found your experts non-credible. So how does that meet the clear error standard?
The Court will proceed to clear error if it rejects our legal arguments, but let me turn to Dr. Ragusa first. All three of Dr. Ragusa's opinions raised in this appeal contradict his own data and conclusions in his initial report, which actually demonstrated that race did not predominate in the enacted plan's changes to District 1. His own data showed that politics was a stronger predictor than race of whether a VTD was moved out of District 1. He also concluded that there was no statistically significant correlation between race and whether VTDs were moved into District 1. That's at page 187 of the Joint Appendix and page 514 of our jurisdictional appendix. So those facts alone establish that Dr. Ragusa's three opinions at issue in this appeal are unreliable and unprobative. But there's even more. For each of those three opinions, Dr. Ragusa committed other errors. He did not control for VTD location or proximity to the district line. He also did not control for where in the district voters live.
Well, I thought he said that as far as geographic contiguity, the size of the different districts was an adequate proxy for that.
He did say that traditional principles were embedded in his analysis, but whatever he meant by that, he did also admit on cross-examination that he didn't test or control for those principles and whether they explained the decisions the General Assembly actually made. That's the same error that the experts made in Allen that this Court set aside just last term. His failure to consider the location of VTDs and voters within the district is the same error that was committed by the expert in Cromartie 2, where this Court reversed a finding of racial gerrymandering under the clear error standard.
Did your expert present an alternative study which did control for geography and reached a different result?
He did not try to mirror Dr. Ragusa's study.
Because that would have been the easiest way to undermine the theory. I mean, as I understand it, this was hardly touched upon by the state below. And certainly the state did not do what would seem to be the normal thing if you were really concerned about this, which is to say, look at our study, we controlled for geography, the results are entirely different.
We did raise objections to Dr. Ragusa's methodology, and as I was explaining, it is a flawed methodology and not reliable. Moreover, the state presented direct testimony from the map drawer to explain which VTDs were chosen and why. That direct evidence showed, like all the other direct evidence, that decisions were made based on politics and traditional principles and not using race at all.
I think you end up in a very poor starting point under clear error, arguing the substance of believability of one expert over another. Because credibility findings under clear error standard must be deferred to the district court. I understand your point about Dr. Ragusa, but I just point out that other experts before the court, and he himself said that geography was very much embedded as part of the structure of his analysis. You may disagree with that. It's going to be very hard for you to show that no fact finder could credit that understanding of his testimony. But I think what I'm really troubled by is going back to Justice Thomas's question. What's the legal error and what's the clear error? Just tick them off for me.
There are several legal errors, Justice Sotomayor.
Not facts. I want legal errors or clear errors that beyond under our standard.
The first legal error is the failure to enforce the alternative map requirement.
Okay, I'm going to butt in. I'm sorry.
Yes, you can start there.
The alternative map requirement, doesn't exist. Sometimes this court, I think, holds things, and then I go back to the opinion, and I think, well, maybe we weren't as clear as we might have been. Not here. I'm just going to read from Cooper. A plaintiff's task is simply to persuade the trial court without any special evidentiary prerequisite that race, not politics, was the predominant consideration. In no area of our equal protection law have we forced plaintiffs to submit one particular form of proof to prevail, nor would it make sense to do so here. An alternative map is merely an evidentiary tool. Neither its presence nor its absence can itself resolve a racial gerrymandering claim. I don't know how to more clearly say that there is no alternative map requirement in these kinds of cases.
Cooper was addressing a case where there was direct evidence of racial predominance. It also said on page 322 in the majority opinion, in a case like Cromartie 2, that is, one in which the plaintiffs had meager direct evidence of a racial gerrymander and needed to rely on evidence of foregone alternatives, only maps of that kind could carry the day.
All we were saying there, Mr. Gore, is that in a case with no other evidence, you needed some evidence. So that is not this case. Cromartie 2 was making a very case-specific point. Look at this case. There's none of this kind of evidence. There's none of that kind of evidence. There's none of the other kind of evidence. So, my gosh, in that case, you needed a map. But this is case by case. All we were saying is that when you have no other evidence, you better present a map. But that's not to say that there's anything like an alternative map requirement. If you make your case some other way, that's good enough. And here, the court found, again, on a clear error standard, that the plaintiffs made their case some other way.
But even if that's the correct reading of Cooper, Justice Kagan, there were still other legal errors in how the panel conducted its analysis.
Well, Mr. Gore, I thought your argument was that, at least as a practical matter, in a case in which there is no direct evidence or virtually no direct evidence, there is no way in which a plaintiff can disentangle race and politics except by providing an alternative map. I thought that was your legal argument.
That is.
And that's exactly what Cooper says is not the case.
Well, one may read Cooper a different way. Cooper was a case in which there was a lot of direct evidence, was there not?